charge. I'm going to type the final version and get it ready to read to the jury.
to the jury.
Welcome back. Thank you for your patience while we worked out everything in preparation for the conclusion of this case. Yesterday, when we left off, the state rested their case. Defense, do you wish to present any evidence?
Your Honor, at this time, we would ask the court to take judicial notice that the date on the night of the Barrientes County Sheriff's election is March 3rd, 2020. And also that the start date, early voting for that primary, was February 8th.
The court will take judicial notice of those two dates that you read for the record. Any evidence you wish to present?
Judge, defense rest.
Very well. Having rested, do both sides rest and close?
Closed. That's what good.
Okay. I have given you the charge of the court. Is there any objections to the form of the charge of the court that I'm about to read to the jurors from either side? Okay. So ladies and gentlemen of the jury, what that means now is that all of the evidence is before you. I'm going to read the charge of the court to you. That is the only way that we can assure that everybody has had it read to them. And it won't take me long, but I do ask that you pay attention. You will actually get a copy. You will get my charge of the court to take back with you to the deliberation room. So you don't have to worry about taking too many notes during this process. Once I conclude the reading of the charge, each side will have 1 hour to do their closing arguments. After that, we will be in recess awaiting your deliberation. So I'll give you more instructions as we get there. For now, I will read the charge of the court to you. In cause number 2021 CR 4408, the State of Texas versus Michelle Barrientes Vela, the charge of the court reads as follows. Members of the jury, the defendant, Michelle Barrientes Vela, stands charged in counts 1 and 2 of the indictment with the offense of tampering with or fabricating physical evidence. Both counts are alleged to have been committed on or about the 26th day of June 2019 in Barrientes County, Texas. The defendant has pleaded not guilty to each count. A person commits the offense of tampering with or fabricating physical evidence if, knowing that an investigation or official proceeding is pending or in progress, she, number 1, alters or conceals any record or document with intent to impair its availability as evidence in the investigation or official proceeding, or makes or uses any record or document with knowledge of its falsity and with intent to affect the course or outcome of the investigation or official proceeding. Official proceeding means any type of administrative, executive, legislative, or judicial proceeding that may be conducted before a public servant. Public servant means a person elected, selected, appointed, employed, or otherwise designated as a juror or grand juror, even if he has not yet qualified for office or assumed his duties. A person acts intentionally with intent with respect to the result of her conduct when it is her conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the circumstances surrounding her conduct when she is aware that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. Now, if you find from the evidence beyond a reasonable doubt that on or about the 26th day of June 2019 in Barrientes County, Texas, the defendant, Michelle Barrientes Vela, knowing that an investigation or official proceeding was pending or in progress, namely a Barrientes County grand jury criminal investigation involving Barrientes County Precinct 2, intentionally or knowingly altered or concealed a record or document, namely Rodriguez Park handwritten cash logs, with intent to impair its availability as evidence in the investigation or official proceeding, then you will find the defendant guilty of tampering with or fabricating physical evidence as charged in count 1. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant not guilty in count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the 26th day of June 2019 in Bexar County, Texas, the defendant, Michelle Barrientes Vela, knowing that an investigation or official proceeding was pending or in progress, namely a Bexar County grand jury criminal investigation involving Bexar County Precinct 2, intentionally or knowingly made or used a record or document, namely Rodriguez Park handwritten cash logs, with knowledge of its falsity and with intent to affect the course or outcome of the investigation or official proceeding, then you will find the defendant guilty of tampering with or fabricating physical evidence as charged in count 2. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant not guilty in count 2. You are instructed that if there's any testimony before you in this case regarding the defendants having committed offenses or acts of misconduct other than the offense alleged against her in the indictment in this case, you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such acts of misconduct, if any were committed, and even then, you may only consider the same in determining the motive or intent, if any, of the defendant, and for no other purpose. Our law provides a defendant may testify in her own behalf if she elects to do so. This, however, is a right accorded to the defendant, and in the event she elects not to testify, that fact cannot be taken as a circumstance against her. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against her. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or a computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, to include but not limited to Facebook, MySpace, LinkedIn, YouTube, or Twitter. Communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purpose of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. The court can send only statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offenses gives rise to no inference of guilt at her trial. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit her and say by your verdict, not guilty. You are instructed that you are not to let bias, prejudice, or sympathy play any part in your deliberations. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. The forms are not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, they shall notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and shall be submitted to the court through the bailiff. Respectfully submitted, Judge Vela J. Mesa, Judge of the 226th District Court. I will sign the charge of the court, and attached to the charge, you will find the appropriate verdict forms. At this time, State, do you wish to make a closing argument?
Yes, Madam Mayor.
Yes.
District Court, Closing Counsel. 10 days ago, I met you in jury selection, and I mentioned common sense and how that's not something that you check at the door when you come to sit on the jury. It's something that you can bring with you on your life experiences with common sense. Once you take away all the distractions, all the noise, all the attempts to trip people up on their words, debates, and attempts to elicit testimony, it is a straightforward, common sense case. You're on this jury because you are people from this community. You are people who are in touch, and you are people who know the law, follow the law. You know, sometimes lawyers think that advocacy means you've got to be loud, you've got to be aggressive, you've got to be tough, and you've got to be confrontational, condescending to witnesses, you've got to move a lot, you've got to be a show. But at the end of the day, in these four walls, the point is that we get to the truth. And so why is this case important? Look, at the end of the day, most of us, we're not going to be elected officials. Most of us, we're not going to be the heads of some organization, the top of a business, or anything like that. Most of us are going to work 40, 50 hours a week, pay our bills. If we're lucky, we got some time to spend with the people we care about. If we're lucky, someday in the future, we get to retire and enjoy our lives away from work, right? And so what is this case about?
You have an elected official who, after an incident at Easter, on Easter, at Rodriguez Park, where there's media attention, and after she's served with a grand jury summons, does what? She goes and writes up 2 clerks for shredding documents. Now, you heard testimony about Michael contesting that write-up because he's like, that's a policy that wasn't even in place. I never even heard of it. I never had notice of this. Susan testified to the same thing, but didn't write in that counseling report. Then the defendant tells Susan, you better get a lawyer. Susan needs her job. She's a clerk at the constable's office. She testified, I need my job to pay my bills. How am I going to go out and spend money on a fancy lawyer, big-time lawyer? So what does she do? She saw the writing on the wall. The writing on the wall that I'm going to be scapegoated. So what did she do when she saw that writing? She went to the law. And so what do we know? So Susan and Michael talked about the security reservation process. Both explained the process to you. They testified that a person would reserve a pavilion, then that person would come into the constable's office and pay for security. Cash only. Cash would then be placed in an envelope and given to the constable, the defendant. Security assignments. The constable would assign those. Deputy O'Neill, Deputy Pena, and Deputy David, also known as Deputy Cardona, testified to that. What did Deputy Vanessa Pena testify to? That she worked security side jobs at Rodriguez Park. She was paid in cash by the defendant for those side jobs. She also testified side jobs are not a part of official duties of the constable's office. And reserve deputies cannot work security, which then leads us to Deputy O'Neill. As a reserve deputy, he worked security at Rodriguez Park about 8 to 10 times as a reserve, and he was not paid. As a full-time deputy, he worked security at Rodriguez Park and was paid in cash by the defendant, Constable Vela. We know that the money citizens paid for security went to Constable Vela in an envelope. So the question is, where did the money go those 8 to 10 times Deputy O'Neill didn't get paid? Bexar County, providing security for Easter. It was early on in the testimony we talked about this. Security was supposed to be paid for by the county. Now there was a security supposed to be for the parks and not for the pavilions. At the end of the day, this is a brief distraction that doesn't really matter to what the overall offense is in the charged case. But the rate was supposed to be at $38 an hour. And the testimony was, in order to participate, each constable's office needed to submit documentation. You heard that from Mark Olivares' testimony. Constable Vela fails to submit documentation after getting into a disagreement about whose park it is or whatever. And even that disagreement doesn't really matter. Doesn't matter. But what Mark Olivares said is important. And here it is, and I'm quoting it directly. That's my question. How does the officer get paid? Of course, this is after we talked about the timesheet being turned in. Olivares, I turn it into Ken, forward it to Bexar County Auditor's Office, and shortly thereafter, the county mails out checks. My question, any money ever given to you directly? Olivares, no. That, you cannot do that. Everything has to be done through Bexar County Parks. Of course, the question is, why can't you do that? Olivares' testimony. It's against the Private Security Board, the Private Security Act. You cannot accept monies to pay officers. You have to be a full-time employee, 32 hours, receive benefits in order to basically provide security services. If not, you would have to be actually running through a security company. So Easter Sunday. Talked a lot about Easter Sunday, April 21st, 2019. There's some things that don't matter. And these are the things that don't matter. It doesn't matter that Jesus Reyes had alcohol. It doesn't matter that Jesus Reyes didn't call before. It doesn't matter that the defendant was well within her right to have ended Jesus Reyes' party or asked him to pay for security. It doesn't really matter. It doesn't matter that it's odd that she's having some event for her office, but then working security for another event or the whole park. That does get kind of convoluted between her inconsistent statements, but whatever. Doesn't matter. Doesn't matter if Henry gave the defendant the wrong date or not. And to be honest with you, common sense tells you what she was trying to do with that phone call. Easter Sunday. What does actually matter? That Constable Vela and her party arrived before Jesus Reyes and his party. Jesus Reyes and the patron from Pavilion 2 each paid $300 for security at a rate of about $50 an hour. Deputy David, also known as Deputy Cardona, worked Pavilion 1 but was paid less than $50 an hour. Deputy Pena testified that when she arrived, a reserve deputy was at Pavilion 2, and once she started working security, the reserve left. And Deputy Pena testified that she was paid about $70. So $600 was given to the defendant for Pavilion security. Where did the rest of the money go? So defendant's inconsistencies about Easter Sunday. The testimony disproves that the defendant worked the Pavilion security. Defendant claims that she paid for security out of her own pocket. Defendant, in an interview, claims she was paid $150 to work Pavilion security. Defendant claims she was entitled to get reimbursed by county for security after she knows she failed to submit the required forms. Another inconsistency, that the Parks and Rec called the defendant and the deputies to be present because of the Jesus Reyes party. Remember, the defendant was there before Jesus Reyes. Why is the defendant's interview inconsistent with what she told Susan to write about her interaction with Jesus Reyes? Which then that leads us to, why is this business record not accurate? So what we see is, on this exhibit, so it's Defense Exhibit 10, the Bexar County Parks and Recs requested for our deputies to be present. Yet, Mr. Reyes failed to pay. So, why is that important? That's a record. And we know from the testimony, and even her own statement, that money was paid, $300. But if you look at this record, and this is what she told Susan over the phone, and we know from testimony, if the constable's office is not open on the weekend, Saturday or Sunday, and we all know, common sense, Easter is on a Sunday, meaning that statement was not dictated until after the holiday. So by this time, Jesus Reyes has paid the $300. But if you look at this record, it said, yet Mr. Reyes failed to pay. So, quick rewind. We'll go back. The handwritten cash logs. Susan testified that she had been in charge of the reservations for some time prior to April 21st of 2019. And that the county auditors told Susan, because of the amount of cash money coming through the constable's office, records should be kept. Susan began keeping handwritten logs. Now, the defendant became aware of this and knew Susan kept records that showed the flow of cash to where? The defendant. And so now there's a tension on Easter. Media is involved in asking questions about Jesus Reyes and Easter. The defendant is served with a grand jury summons on June 11th, 2019. Defendant issues a verbal counseling to two clerks on June 19th of 2019. Michael contests this because of the lack of notice about the policy and said he shredded documents with the prior constable's name. Susan testifies it was not a policy she had notice of. Both Michael and Susan given copies of that policy on June 19th, 2019. The defendant tells Susan to get a lawyer. Common sense tells you Susan saw the writing on the wall. She was about to be scapegoated. So the defendant is served with a grand jury summons. Susan ordered to make 7 copies of all documents related to Rodriguez Park. Susan has the handwritten cash logs in every one of those copies. Defendant takes one home. Susan goes to Ranger Freeman. Susan knows that the defendant took a copy home. Susan knows The defendant doesn't like that the handwritten cash logs exist because they give information showing the money trail. Susan knows that it is possible that the defendant may conceal them. And of course, quick side, conceal means simply to hide or to keep. Now, the defendant's involvement with the records. A lot of common sense going on here, and we can see right through it. The defendant hires Les. Defendant tells Susan to make copies. Defendant takes one home. Les says someone dropped off a copy at his office. Susan testifies she's never met or been to Les's office. Les delivers documents to the DA's office, conveniently without a business records affidavit. Les is given the documents back, and the defendant acknowledges this in an email. So anytime that comes up about, oh, well, who knows how, maybe she never even knew about these records, what records are being turned over, anything like that, simply go to State's Exhibit 40, the email, where she acknowledges being aware of this grand jury summons and what's been turned over. Simple. This is facts. This is evidence. No matter how much we get loud about it, we jump up and down, we move a lot, this will always stay constant. This will always be a fact. After that second grand jury summons is served on the defendant, Susan is told to make an absence of business records affidavit. Now, common sense tells you what? The defendant is trying to separate herself from these documents. Let me have a layer in between me. Let me scapegoat somebody. Simple. So, bunch of distractions. Susan wore a wire. Okay, cool. Not a big, what? Big distraction. That this is a great conspiracy because Michelle Vela decided to run for sheriff. To be honest with you, this argument is an insult to your intelligence. We know that she didn't announce to run for sheriff until after the Texas Rangers and the FBI are executing a search warrant on the Constable precinct's office. Anthony Castillo said, "Go tell the truth." And Ranger Freeman didn't write evidence of innocence in his report because Anthony Castillo said, "Go tell the truth," and Susan said it was Constable Vela. Again, also an insult to your intelligence. Like, Constable Vela's in a room, in an open area with multiple people there, and she did not say, "Go tell the truth." And just the fact, because the wire, the recording, whatever you want to call it, doesn't capture, say, "Oh, make sure you lie to that investigator and don't say the truth and don't tell him about X, Y, and Z," that doesn't mean anything. It's a distraction. So what are the Susan scapegoat attacks? Susan, for some reason, decided to frame Constable Vela because she was upset that she got a verbal counseling about shredding documents, even though she was planning to move to Seattle. So instead of just moving, she decides to go to the Rangers and FBI, participate in an investigation, then continue and subject herself to 3 days of direct examination and cross-examination because she is very upset about that verbal counseling she got back in 2019. Again, yes, written down, it is pretty silly, and it is an insult to your intelligence. The motion to compel that was brought up, ridiculous argument. There's been no assertion of privilege or reason to withhold the documents, that an elected official gets to withhold these documents. The defendant didn't even acknowledge that these documents were being withheld. But for Susan, we don't even know that the documents exist. Again, this is another argument that is an insult to your intelligence and takes us away from what this case is about, just common sense, straightforward. Words matter. We proved our case. The grand jury summons said any documents related to Rodriguez Park, and then had that such as and listed examples of those types of documents. The defendant concealed documents after being served with a grand jury summons, and she was given 2 opportunities to comply. And after being served with a grand jury summons, the defendant makes false records, false documents. And Don's going to speak more to that part. Remember, in jury selection, when I spoke to you, we talked about this. The crime of making a false document happens when the defendant makes a document she knows is false. And at the time it is made, it is done with the intent to effect an investigation. So the crime happens when she makes a document knowing that it could affect the investigation. It doesn't matter that she didn't turn over the documents. Again, common sense. We proved this case. This is a public corruption case. It is about a cover-up and an attempt by an elected official to scapegoat an employee. Find her guilty of both counts. Tell her what she already knows. Thank you.
Do you want the remaining time, Don, to your side?
Yes.
And may I have a moment before my time starts to say?
In your honor, I approach the
Your Honor, how many minutes do you
I'll
use?
use 20.
Only use 20? Okay. It's fast.
May it please the board. Opposing counsel, members of the jury. If you let them do this to her, you're saying that you're willing to let them do this to anybody. Any mother, any brother, any neighbor, any friend. If you let them do this to her, what you're saying by that is that you're willing to let them do this to anybody. Now what they've tried to say is, oh, this is, Oscar said, we're not all going to be elected officials. We're not all going to be, but that's the thing, and that's what Nico talked about in the beginning, and that's what he's going to talk about at the end. Is that it doesn't matter who's in this chair, because the verdict that you give says, I am willing to let you do this to her. I'm willing to let you start an investigation. I'm willing to let you be weird about how you ask for things and documents, and I'm willing to say that you concealed something that now, you all know, was sitting on Susan's desk the entire time. Sitting on Susan's desk the entire time. That's what, count one in the charge is concealed. Count one, they're trying to say, and they're saying that common sense tells you that she was trying to conceal something that she never ever had possession of. Susan said, I've always had possession of it, and was sitting on Susan's desk. And that's concealment. And Oscar said, he said, conceal means to keep. See, that's the problem we have here, is that they're not operating on definitions and they're not using their words right, because conceal does not mean to keep. I'm keeping this right now, it is not concealed. That's it. I'm keeping it, not concealed. Susan kept all those documents, and they were not concealed. They were sitting right there. And think about common sense. Somebody who wants to do that would never, ever, 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 ever leave those documents in the possession of somebody else. They wouldn't do it. They wouldn't do it. So there's another explanation, and the explanation is the one that they have tried as hard as they can to not see this entire case. But I want to go back to the beginning, because the one thing that I told Nico is I want to be able to talk to you guys right now and talk to you about what I said in opening, because you heard from me first. And the first thing I said was they set a trap. They set a trap and they didn't get anything. They didn't get what they were trying to get from her. They didn't get anything off the wire. They didn't get her to make any admissions. But what did they promise you? They said Deputy Pena was shorted money by Michelle when Pena worked Rodriguez Park on Easter. That's what they said. We did the math. She wasn't shorted. That was something they said at the very beginning to try to make you believe that she was stealing money from her deputies. And it was not true. The first to speak sounds right until the cross-examination begins. Deputy Pena will tell you that Michelle said, get me all the reserves you can get me. She never testified to that at all. Never said it. They said the handwritten cash logs written by Michelle
would be in 2 different colors of ink with different pens to make it look like the record had been created over time. And when she said that, that sounds bad. What? She was doing that? But then when Susan got up there, she said, the only one that you can see that are in 2 different colors. She said, I don't even know who wrote those. What, me, I'm part of it, but it wasn't her writing. That's what I'm saying. In opening statements, those are not just telling you what the evidence is, they're auditions. There are auditions to you about how, can you trust us? Can you trust what we're telling you about the evidence? And when I went through that timeline, you saw with every witness that everything I told you in opening statement came out in this trial. Everything. And they continue to try to, whatever they can think of in their heads to make you think that she's a bad person, that she's guilty, that she's stealing. It's ludicrous. It is. It's ludicrous. That she's even sitting here is ludicrous. That they would do this to somebody in our community. I don't care who they are. It's crazy. This thing is crazy. This sheet that they're talking about, she testified. It's not her writing. It doesn't have anything to do with Michelle. Deputy Calvin O'Neill, and Oscar talked about this, testified on direct he was a reserve deputy from June 18 to June 19. You heard him say that when Don was asking the question. 1 year, I was a reserve. And then he said, and I was working reserve, or security as a reserve, and I wasn't getting paid. But on cross-examination, you had to admit he was actually only reserved from June to November. He didn't testify correctly to you. I brought his actual record, his employment records up there, and he had to say, oh, I was wrong. But it makes a huge difference, because you're going to see him on the cash logs. After November, you're going to see him there. But before that, the only time you see him on a cash log is before he even starts as a reserve. And he's there with 2 other officers. Because just like anybody, you go and kind of see what's going on before you start your job. And he didn't get paid for that. Because he was watching them. There was 2 officers and they both got paid. Full-time deputies, they got paid. That's the only time you see O'Neill on there. In the security agreement, when O'Neill is written there. That was in May of 2019. But if we just left it there, after 2018, he's full-time. So, if they just left it there, think about that. He's the only person they brought you to testify working security as a reserve. He was wildly inaccurate when he testified to you about it, and the state was willing to let him do it. That did not get corrected until I brought his employment record up. They got access to that because it doesn't fit their narrative. They need him to be a reserve all the way to June, so that when you look at those documents, it looks like he was working as a reserve. And she was keeping the money. That's reasonable doubt right there. He doesn't even know when he was working. And they want you to say that is evidence beyond a reasonable doubt that where's the money? Where's the money? Ken McGlammer, director of Bear County Parks, testified Eastern County Security Program had nothing to do with pavilion security. They were completely separate. Testified Henry Guerrero, not Michelle, was the one who made the mistake. And this is important too. On cross-examination, I showed him his report, and he looked and he said, yeah, it was Henry. Yeah, we looked into it, and it was Henry that actually made the mistake. And then what did they do? That's what I'm saying. This is why I can't understand this. Then they put Henry on to say, no, it wasn't my mistake, it was her. They don't care how the evidence is coming out here. They have their plan, and they're going to do it. They're going to put a guy who told you a falsehood. And just with McGlamry, just so it's cleared up, March 21st, 2019, he is asking the constable's office for that security on that day. So on the video when Michelle says, look, we were requested by them, by the parks, that's his email, that's in the evidence. Asking them for those officers. Michelle was one of the ones that worked. You'll also see here, this will be in addition to any reservation holder event security. They're completely separate. I know that this is confusing. Park security, pavilion security. From the beginning, it's been determined, but all of ours, what did he try to tell you? He tried to tell you, well, honestly, they shouldn't have even had to pay because we were covering the whole park. But that's not how it worked. Henry, when I talked to him, that's the thing I made. He said, I got my email cancellations about on Friday. Michelle called me on Saturday. I had no other communication before that. But then what did you see? 419. Hi, Bella, this is Henry. Here's what it costs to rent pavilion number 1, which is the pavilion we're talking about. Okay, I'll have the money for you on Sunday. I'll be there by 7 a.m. I also work too, thank you. And here's the other thing. All of this stuff about it's weird that she would have this event and work. She's a mother. She's got a family. Who wouldn't want to be like, look, I have to work for my family, but I'm working in a park. Why don't you all come there? I can walk around the park, I can do the security, and I can see my people. That's not weird. My mother would do it. Anybody's mother would. Anybody's father would. If you had the opportunity to do it, and she thought that she did, because Henry told her and he made a mistake. I told you in opening statement, I said, Henry made a mistake. And it came true in the evidence. And that is, you can't say that about what they're telling you. Susan Tristan never testified she put cash logs in the subpoena response. Never testified that Michelle took documents out of the stack. You had no testimony. There's all this intimation, but you have no testimony. None whatsoever that Michelle took documents out. That Michelle told her, hide these records, or destroy these records, or let me have these records. Think about 7 copies. Because the state keeps saying common sense, and I know we talked about advocacy. This isn't advocacy. I'm a little loud and furious. I'm furious about this. And you should be too. Ranger Freeman said, well, gas mileage from Austin for a different ranger who doesn't have a personal relationship with Don, that's a waste of taxpayers' money. What is this? What is this? I'd rather pay the gas mileage for another ranger that can tell these people, we don't have anything here. You can't indict her for tampering. You can't indict her for something that nobody has ever, in the grand jury prosecutor's opinion, imposition, nobody's ever done this before. How about you just call the person? He said, hey, people just call me, we work it out. Well, she didn't have him. She didn't have that grand jury prosecutor, she had her. That's who she had. Nobody was trying to call and work it out. They were trying to figure out how they can get what they want to get without really telling her what it is they want to get. But 7 copies, think of that. They're saying use your common sense, and they're saying that she believed that these documents are harmful to her, that they contain things in these documents that would hurt her or that she's trying to hide. And she instructs somebody to make 7 copies of it. How does that make any sense? It doesn't. The only way it makes sense is if she's not guilty. She's trying to figure this stuff out. It's confusing. Thank you, Judge. Susan kept the originals with her the entire time. And so we'll look at these pictures. Again, this is their whole case. These are where the handwritten cash logs are. Never out of Susan's possession. But they say use your common sense. And I'll just say, it is a fact that every time that somebody sits on a jury, you are making decisions about who we are. You're making decisions about everybody else in the county and what we're willing to tolerate. And if you're willing to let them do this to her, what you're saying with that verdict is that you're willing to let them do it to anybody. And in this case, it boggles belief. The jury charge says concealed in count 1. How can you not have a reasonable doubt that she concealed something that she never took? There was no evidence whatsoever that she tried to do anything with it. None. It's empty, it's a hole. Handwritten cash logs in count 2. They never provided any evidence that it was made and it was false. They don't have any evidence that it was false. They only said, oh, well, this is different than this. But the explanation could be, oh, well, somebody was scheduled to work and then they couldn't and somebody else worked it. That's what reasonable doubt is. If you can have an explanation like that and it's reasonable, that's not guilty. Because they didn't provide anybody to say that anything on there was false or that it was a lie or that it wasn't true. No witness said anything about it. No witness said anything about it. And remember, with the handwritten cash logs that they're talking about in count 2, they have to show that she made it knowing that the grand jury investigation was pending. And so I'm going to sit down, and I know Nico wants to talk to you. And he gave me this opportunity, and we talked about this, and I appreciate it. I wanted to look you in the eyes and say, what I told you in opening statement came out. What they told you didn't. And if you let them do this to her, you're going to let them do it to anybody.
We never mentioned cash logs. How many times did you hear that from Ranger Freeman? We never mentioned cash logs, but this is all about cash logs.
You heard that. That's in the indictment. The judge has read it to you. You're going to take it back there.
I want to make a quick comment before I get into the evidence. There's a trial lawyer saying that says when you have the law on your side, you argue the law. When you have the facts on your side, you argue the facts. When you have neither, you make comments about opposing counsel. I don't apologize. With all due respect, please hear my heart when I say this. I don't apologize for representing any one of my clients. And my client today is Michelle Barrientes Vela. I'm proud to represent her. We talked about this in board. I remember in jury selection, that during the state's case, it's gonna sound like a waltz, it's gonna look like a waltz. It was a very bumpy waltz, but it was gonna be a waltz, and then when we asked questions, it was gonna be like a tooth extraction. Remember we talked about that? Because I didn't know how he was gonna testify. We didn't know how their witnesses were gonna testify. We knew what the evidence was, and many times we knew the evidence better than them. And they've had this case for how many years? And they spent how much of our taxpayer resources on this to find justice? Well, the reason why I get passionate is because of what we talked about during jury selection. I am passionate about our justice system. I've done it from both sides. I was the district attorney, as we talked about before, and I'm a defense attorney now, and I love doing both jobs. They both have a purpose in our community. But that means something to me. That represents our Constitution. Constitution means our structure. The structure that sets the tone for anybody in our community. Forget me, forget us, it's about the community as well. Remember I said today, this week, it's gonna be about Michelle? But it's really about anybody that's sitting in that chair. And we went over what everything means, but specifically what that means. The blindfold. It's not made out of mesh, and you're not supposed to do this when you want to. It's supposed to be over your eyes. We talked about in jury selection that we don't prosecute politics. We don't prosecute personalities. Can you imagine? In the history of our lives, as all of us, as we mature in this thing called life, if we ever got prosecuted for a season in our lives, we'd all be in trouble at some point in our lives before we mature. And we don't prosecute ideology. We talked about it in jury selection. Last part, the role of the jury, we talked about this as well. I think this is the strongest statement you're going to read about your role. Why our system was set up of the people, by the people, and for the people, because you're the big equalizer we talked about. I consider Thomas Jefferson, I consider trial by jury as the only anchor when the government starts drifting out of the bay, the only anchor yet imagined by man by which government can be held to the principles of our structure, of our Constitution, right? And that's why you're here. You are the big equalizer in Lady Justice. You're the one that balances all this out. You're the one that when the government, with all their resources and all the media talks, and they start this narrative and this, remember Jason talked about that snowball? You're the snowball killer. That's how our system is set up, of our peers, of the people, by the people, and for the people, and we're thankful for that. So, I mean, Oscar's heard me say this before. I used to work with him, the 3 C's. I mean, common sense, right? That was nice. I mean, you didn't check it in at the door. I mean, that's a metal detector, not a common sense detector, right? Use your common sense. Can you listen to what they're saying to you, as Jason said? Can you hear what they're saying? I mean, I'm sitting there, and if you see me shake my head, I know I'm very expressive. That's the way God wired me, I'm sorry. But I mean, it baffles me sometimes when I hear some of the arguments they're making. Consistency, or inconsistencies. What is consistent and what hasn't been consistent in this case? How many times did Ranger Freeman from the stand, and I won't go over all of them, say, hey, Don, where are you referring to? Just shout it out, Don. Just go to the Don and Bradley show, it seemed like it was. Just shout it out. Go here, Bradley, go here, Brad. And that's how it sounded. That's not consistent as someone that knows these cases very well, knows this situation, they had it so long. But ultimately, it's about credibility. The judge told you that. The judge is the judge of the law. You're the judge of credibility, and you're supposed to judge everyone's credibility as they come before you to give you testimony. So let's talk about this. So Easter Sunday, Jason went over this with you. So this is the incident. Have you noticed that she's not charged with anything from Easter Sunday? Why? Because they don't want to talk about tampering. They went to the first 4 days of trial. 4 days. I was just waiting. I was like, can we move along, guys? You know it's not in the indictment. 4 days in trial, we're talking about everything other than what's in the indictment. All right? So then on May 9th, I still don't know where Christine Del Prado is. She is their division chief. You saw her on jury selection day. Remember her? She came up here. She was here. And she's the one that initiated this agency because she reached out to Freeman. She hasn't been here for 2 weeks. She's not here. I don't know why. And so he testified to that a DA's office is not usually an initiating agency. They're a reviewing agency. But they're the initiating agency in this situation. The DA's office initiated this investigation. So we have 6-3. This is important because it was memorialized on 6/19. Remember that reprimand? But it was referencing back. Remember this reprimand? It was referencing back to 6/3. Why is that important? Because this stuff was being acknowledged and reprimanded and attempted to be corrected by Michelle before she even was given a subpoena. How can they say that she knew? She's a mind reader, so she knew what Brad and Dawn were cooking up. And she says, I'm going to have her voluntarily sign this. We don't see any objection, nor did Susan testify to any, by the way. No objection. She was shredding documents. She said it. And she was shredding which documents? Remember that? Security agreements. Why is that important? Because after the first subpoena comes, what are they asking for? Security agreement contract records. They didn't ask for cash logs. Security agreement contract records. And it's right there. And remember, Ms. Bradley Freeman, Ranger Freeman said, and we even bolded it for him, for her, for whoever the custodian of record was, but they knew who they were talking to. Security agreement contract records. There's no mention. He said it over and over again. And I was just trying to walk him through it. We never asked for cash logs. I know, Ranger Freeman, can we just, let's walk through it. We never asked for cash logs. You know what's in the indictment, right? Yes, we never asked for cash logs. He testified that he had something like this in his hand. He was on this, right? This was in my hand when I drafted up that first subpoena. He drafted all of them, by the way, right? This was what he was holding in his hand. We're going to dissect this here in a second. We never mentioned cash logs. That's the only thing in your indictment. So now we have 612. So the subpoena is given. Susan, Tristan, he calls her Susan, calls Ranger Freeman. This is going to be very important, guys, because you have to listen. Look, what we talk about is one thing. Hopefully you take it in. But it's all about the evidence that you have to consider back there. Susan called. She testified from the stand. They had the opportunity. They've been talking to her for 3 years. They could have asked her anything they wanted. She never said that on this date or this date, Michelle told her to make anything, hide anything, destroy anything. You didn't hear that. You'd have to make it up. You would have to insert evidence in there and say, well, if she would have done it. No, it didn't happen. She was right here. Dawn and Oscar could have asked her any question they wanted to. She never testified to that. She actually says, and we're going to get to it in a second, that she didn't talk to Michelle about collecting records at some point till way after, so sometime down the road. So doesn't talk to Michelle here. That's the subpoena. They allege, and this is what's not going to make sense, that in the morning, I think Susan said, you need a lawyer. That's what Michelle allegedly said to her, and then walked into her office. And that was it. Okay, I guess doesn't make sense because you heard a recording, all right? You heard a recording of Michelle when she didn't know she was being recorded. So you're getting her raw. And she didn't say that, and we're going to go over what she did say in the recording, and it's Freeman testified to. So here it is. Susan Tristan meets a Ranger Freeman and provides, remember those cash logs? This is Susan's system. She testified to it, Ranger Freeman, this is not Michelle's system. She's the custodian of records. She was mentioned on the Parks and Recs website. If you want to register, call Susan Tristan. That's it. This is her records. I asked Ranger Freeman, what about the records from all of 2017? Oh, we don't have them. How about, I asked him, there's certain portions of 2018, we don't have them. Did you check into them? Well, no. Well, isn't that kind of important? I mean, it sounds like Susan's system is kind of jacked up on its own. It's messy. This is messy, okay? But this is what she turned over to him. Remember, these were the documents. They're right here. It's added into evidence, but I'm just trying to save some time. So this is June 13th. This is what we know for sure, that Susan Tristan, on her own, knowing that they're looking for security agreements, knowing that she shredded security agreements, knowing that she was reprimanded before June 11th for security agreements, she just rushes to Ranger Freeman and gives him cash logs. That's what we're talking about here. First subpoena. First subpoena, no talk with Michelle. Calls Ranger Freeman, no talk with Michelle. Then she goes to meet with Ranger Freeman, and she gives him all of these cash logs. Now, Oscar mentioned it. I promise you, guarantee, Ms. McGraw is going to come up here, the government's going to come up here and focus on these. This is evidence they're going to want you to believe that Michelle made some documents to trick them in their grand jury investigation for security agreements, which they got a bunch of security agreements. This was made before. This is a working document. Did you hear any evidence that this was intended to be turned in, this scribble? These were made before the subpoena was even issued. This was after Michelle realized that Susan Tristan was shredding documents, trying to put that all together. She testified that she didn't talk to Michelle about any of this record keeping or collecting until after she met with Ranger Freeman. So they cannot, in good conscience, let me make this statement, I say this humbly, but very directly. They cannot, in good conscience, based off the evidence, not my opinion, based off the evidence, tell you that that was made in response to the subpoena. Because Susan Tristan didn't say that. She said the opposite. So now we're at 6:18. Susan Tristan meets with the FBI and Freeman for the second time. Because remember, it's a joint investigation. 6:19. Susan Tristan meets with FBI and Freeman a third time. You're not recording these meetings. That's important. That dialogue, that raw conversation, who's saying what and how they're saying it, that's important. He didn't record it. He could have. He wanted to go back and forth, federal standards versus state standards. I asked him very direct questions. He couldn't give you, there was no legal reason why he didn't record that. Not only did he not audibly record many of these meetings, he didn't notate some of them either. He could have done that for sure. He didn't put the June 18 meeting in his notes. But listen what he said. I didn't believe it was relevant. Says who? What's relevant to you? Now, so now he's acting as investigator, judge. She determines what's relevant, and working with the prosecution all in conjunction. It's been centralized, and that's not the way our system is set up. That's not due process. That's not fundamental fair play. So we have now 2/15, June 25th. Susan Tristan, listen to this one. You guys know this. Meets with FBI and Freeman for a fourth time. No conversations of her being pressured or doing anything. No conversations of that Michelle made me make these records. None. She was here. She didn't testify to any of this. But what we do know is she wears a wire for the first time. A secret, covert device that records things. Then they come back for more. Why did they come back for more? Because they didn't get anything the first time. The problem is, these aren't notated. Ranger Freeman doesn't say in his report, CHS or CS or CI was given a covert recording device, date labeled, blah, 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 number, whatever. She had it all day long, continually in her presence, returned back to me by 7 p.m. He didn't use military time, I forgot. 7 p.m., nothing of significance in the recording. None of that. Didn't document any of it because it wasn't relevant to him. Doesn't mean it wouldn't be relevant to you. So 6:25, 6:26, nothing. Recorded conversations. She could have, this is where she was trying to get Michelle raw. Where she would have said, hey, Susan, remember those documents we made back on 6/12? Make sure you don't turn those over. Or better yet, give them to me. Look. Michelle must be the worst criminal in the world. Instructing Susan to make 7 copies. That's what she testified. Susan, make 7 copies, please. 7 copies of documents they want? Yeah, make 7 copies, please. Okay. But yet she's trying to hide these cache logs, but I'm going to give you the originals. I have a key to the place. You keep it on your desk. I can go there at 2 in the morning whenever I want to. Sorry. And do this. And she didn't do any of that? She's the worst criminal in the world. Can you imagine that? Please use common sense. This makes no sense. And that's why Jason is a little peeved off, right? We did their job for years. So 6/26/19. Second wire, no evidence. No incriminating evidence on either of these secret wires. But I asked him, if we were just to read your report, if we didn't have the constitutionally and structurally protection of cross-examination, if we didn't have the right and the protection and the balance of trial by jury, it reads differently. Well, I just didn't think it was relevant. Wow, that's scary. So yes, I got passionate, guys. If I offended you, will you please accept my apology, okay? I mean that. Please don't hold it against Michelle. You can tell me after and call me whatever name you want to, but please don't hold it against Michelle. If Jason has offended you in any way, please accept his apology, because I know his heart as well. But because I'm offended by how the state has handled this case. And I'm offended how this investigation was handled after looking at many of them over my career. So, no incriminating evidence. That's kind of important, guys, but you would have known about it if we didn't ask. Nothing about this in his report. But here's what we know about on June 26th. So think about this. Let's do a little timeline. So 6/13, she's come in contact with him and is giving these cache logs. 13 days later, within 13 days, he knows not only that there's cache logs that he could be asking for, but that Susan Tristan has a plan to move to Seattle. Kind of important. And I asked him on 2 different occasions. I said, Ranger Freeman, do you think it's relevant at all if you have a witness
that knows you're asking for cash logs, has shredded those cash logs. There's a document admitting that she shredded those cash logs and wants to move to Seattle. Is that something just to flush out? That wasn't some secret defense theory. We didn't say that was for sure. I just said, is that part of your due process when you're eliminating things? We're going to talk about what Ranger Freeman said he was trying to do in his investigations. Is this part of getting all the facts? We trusted Susan Tristan. I stopped counting after 7. I did. I don't know if you counted more. We trusted Susan Tristan. I jokingly said, how tall are you? I thought he was going to say, we trust Susan Tristan, but he said 6'4". So here we're back on 7. We're July 18th. DA sends the second subpoena. Now, I'm not going to go through it because you guys have it in evidence. There's 4 of them total. We never mentioned cash logs. He said that again. So now we're going to spend some time here. 7/24. Susan wears the wiretap for the 3rd time and meets Freeman for the 5th time, and then gives more of this of Susan's system. See, so she's revealing her system to Bradley, as she calls him, which is odd. I mean, within 2 weeks you're calling Ranger Bradley, but so she gives them what? What does she turn over? Because Ranger Freeman says that new evidence was revealed to me. That's what he said. This was revealed to him. Remember I went through this exercise? I said, what does reveal mean to you? Something new that was made unknown, known. Number 3 was given to you on 6/13. Number 5 was given to you on 6/13. There's nothing revealed here. Well, that's my, so these are duplicates. Well, and he went back and forth with me for a little while, but then admitted that. He testified on the first day. This is why this is important. What did he tell you when they brought him up here the first day? The purpose of investigation is to present the facts. In your heart of hearts, do you believe that they presented you all the facts? But that means to me that if we weren't here to cross-examine, Jason and I and our team, to do what we do, would you have a clear understanding of what's going on? That's what that means to me. I did it. I understand that process. To ensure justice is done, present all the facts. Present the facts. And find the truth. Part of finding the truth is finding evidence of innocence. We talked about that. Because he said whether someone did something or didn't do something, it's just as important. This is in his transcript. It's just as important if the facts say a person didn't do something wrong. If it wasn't for the constitutional protection and due process protection of cross-examination and effective assistance of counsel, would you know the full picture? And you would not. He testified on the last day. They came up with a plan. The first 2 secret wires didn't work, so we have to have a plan. And their plan was what? And Jason likes to call it a trap, and it's true. But what was this plan trap? Man, nothing's happening. I don't know why. I'll do this. Let's do a fake call. And then you act fake nervous. So fake call, fake nervous. He testified that, and it's a strategy, I believe he called it. They can lie. And I'm not saying, I mean, that's just the way it is. If we like it or not, they can lie. They came up with a strategy. Fake call, she acted nervous. That was the plan. To hope, they were going to hope to try to secretly record Michelle saying something incriminating. But nothing happened. There was no incriminating. Oh, they provoked the information, I promise you that, but not the information they wanted. Susan Tristan told Ranger Freeman on that wire, on the secret wire that he accidentally recorded himself. That's why I get passionate, guys. You have a ranger that was trying to do his job, fair enough, and secretly record a suspect, but accidentally recorded himself and revealed evidence of innocence, and it's nowhere in a report. They didn't tell us about it. They turned over the recording. But no one said, hey, by the way, this is some Brady, this is some evidence of exoneration. Here it is. Nobody told us. If we didn't scour through all of this, and he didn't want to admit it. Michelle, in that recording, Susan tells Freeman, when I was leaving, right before I left, Michelle told me, don't worry about this. Just be truthful. We didn't do anything wrong. Now, there was some evidence that Chief Castillo said that. But let me tell you exactly what happened. They were all there. Remember, Susan said it. This was the collective idea of the whole administration. They were all there in some room. Michelle didn't say, hey, Susan, hold on, before you go meet with them. Hey, don't forget about those things I wrote. Remember those ones I drew out? Hey, don't forget about the things that I told you to do. Nothing. What does Michelle say for sure? They heard. He heard on the wire when he spot listened to it. Remember that? Remember when I went back and forth with him, and this is why I was getting passionate? He said, I didn't listen to the wires. I said, why not? Because, I'm going to pause, because it was really amazing to me. Because Susan Tristan told me there was nothing important on those wires. Susan Tristan, a CHS, I guess he trusts her completely. He said he did over time. So she could have told him anything. Susan Tristan told me that there was nothing important on those wires. But guys, there was something very important on those wires. Because not only did you hear Chief Castillo that Susan took at it was Michelle's statement, because Michelle was there going, yeah, just tell the truth. Do whatever you feel is right. Michelle's voice, by the way, Freeman testified to it. You're going to be good. Relax and breathe. Because remember, she was faking being nervous. So Michelle said, relax, breathe, you're going to be good. Freeman didn't write any of this down. Does that make any sense? Is that the same person that on 6/12 walked in and said, get a lawyer, you need it, and walked off? That doesn't make any sense. That doesn't pass the smell test, as my pop used to teach me. Freeman doesn't write any of this in his report. So we get to 6/20. This is that fourth subpoena that we went back and forth on, right? Here it is. We're going to dissect it. And this is what he said. He said, the reason why I wrote it this way is because I didn't want to appear to be tricky. Okay, well, let's dissect that. So in this final, by the way, this is, remember, August 20th? They've known of these cash logs since 6/13. I said, why do we call this a receipt? Because it says receipt. I know, it's not a trick question. Why do we call this security agreement? Because it says security agreement. Why do we call this cash log? Because he said it clearly says cash log on the top. I go, exactly. But they don't even ask for cash logs again. We never ask for cash logs. Names of the officers. There it is on 2 security agreements. Individual dates and events that were assigned. Dates, events that are assigned. Type of event, date of event. Time that is supposed to work. Pavilion. It has a place for pavilion. This is describing security agreements, which they've already given over. Remember, I went through 18 of them or 17 of them with them? They responded with that. Hours worked. Compensation received. Now, they're going to argue, well, don't you know? Can't you read my mind? It also means cash logs. So they're going to say this. This is Susan's system. See, names of officers. Just says received by, and then it says date. This cash log, which is Susan's, doesn't even have a column for the officer. She wrote it in herself. Her own system. The event, not on some of these cash logs. He's on one of them. She's not consistent. There's one that's not. Another one there's no event on. Time. Neither one of them have time. None of the cash logs have time. Pavilion. Remember this one? So Ranger Freeman sits up here, and he's sitting, and Don goes, well, don't you see? Can you see from over here? I like a challenge, Don. He goes, I can't see. You don't see P2? Oh, yes, there it is. There is P2 there. So yes, I did get a little frustrated. Can we say that? Because he didn't know it was there. He didn't know 7 minutes earlier that P2 meant pavilion. She just told him during direct examination, or redirect examination. But he had the audacity to tell you guys that that's what that meant. She hadn't even seen it. I think went up close to it and said, how can you tell? Not there. Hours worked, no cash log has hours worked. But somehow, Michelle and Les, not just Michelle, because they don't want to talk about her attorney. She hired an attorney and says, I don't know what they're asking for. Les, who worked for the DA's office for 22 years in the civil section, he goes, this was confusing. She got a lawyer, not because she was afraid, because she wanted to comply. And she asked someone that has been in that world, in the lawyer world, speaking lawyer language. And he was confused, right? Compensation received, well, of course there's going to be money on a cash log. It's called a what? Cash log, okay. We never mentioned cash logs. So 8/29, she meets with him. And this is the last portion of our little diagram that we did with Susan's system. Remember she turned over, remember he said additional cash logs. We went through what do words mean. Additional. These aren't additional. These are all duplicates once again. But if we are relying on his report alone, if we just read it, we think that there's this influx of these cash logs. By the way, and they're not. They're all duplicates from day one, from 6/13, same ones. So here's 9/23. FBI raid, 23 FBI agents, it's a few state agents, he says, including himself. And by the way, this is the day that Michelle announces for sheriff. That's it. It's something to consider. I'm just saying, this is something to consider. No one's saying that's our theme or our theory. It's just something to consider. There's Michelle. There's Susan Tristan's desk. Ranger Freeman didn't even know that was her desk. Do we really believe that? Can we use some common sense? In all of his investigative techniques, he doesn't even know where Susan Tristan sits. She sits here. Remember 31 that Jason talked to you about? There it is. Guess what was found in item 31? You guys heard it. All these cash logs and receipts and other documents. We have that purple folder here somewhere. All the cash logs were here. And you know what? I remember I asked him the only why that some of these original cash logs, because these were the originals. She never gave them originals. Always copies. The reason why there's extra, remember? Because she has a working document. She worked for another 3 months on these cash logs because people are renting the pavilion. That's why there's the addition. It wasn't Michelle, it's Susan's handwriting. Receipts, cash logs, in Susan's system, on Susan's desk, out in the open for anyone to get, including Michelle, if she wanted to hide them or destroy them. Doesn't make any sense. So, 924. 923, 924, Susan Tristan quits. She quits. I'm done. My job is done. She considered herself undercover. Right? And they treated her like she was undercover, by the way. I've never heard of somebody treating a cooperating human source this way. Trusting them no matter what. Right? Calling them Susan and Bradley. I've never heard of that. 924, she quits. Michelle's indicted on January 2020. She's indicted for cash logs, right? Bexar County primary, not even 6 weeks later, but the primary, early voting started 4 weeks later. We said she wasn't in office. There was nothing to hide. Nobody was in danger. Nobody's life or liberty was in danger. None of that thing. The state brings up their last witness to you. Their last witness is a grand jury prosecutor. He testifies that there's motions to compel. Jason talked about this. I work with a lot of lawyers. I've always worked it out. We just talk. I'm clear about what I want. He's clear. There's no mystery. Here's what I'm looking for. Can we do it? If not, guess what you do? You go to a judge. Hey, judge, they don't want to turn it over. We want this. They make arguments. The judge says, turn it over. Then when that happens, now you have a problem. That didn't happen here. They circumvented that. See, they don't want a judge involved. They don't definitely. We want you involved, thank God. But that's not what they wanted to do. His testimony. He prosecuted in Oasis County. I don't even know why they called him. I'm grateful. I really am grateful they called him. I have never seen a prosecution for tampering with evidence, for not providing materials in response to a grand jury subpoena in my entire career. So can you see why Jason and I are a little bit, because we believe in this thing with the blindfold and the scales and the sword and the foot on the book and the serpent being crushed out. I believe in that. It's not just theory to me. I've done it on both sides. So has Jason. We believe in that. It didn't happen here. And we can't prosecute personalities. We can't prosecute politics. We can't prosecute ideology. That's not the way this thing is set up. That's not our structure for the system. Because be careful the world you help create, because someday you may have to live in it, right? That's what my pop taught me. My pop taught me a lot of things. So what they want you to do is do as I say, not as I do. So they can conceal stuff from us. Ranger can conceal stuff. They cannot write stuff down. Where's the accountability there? See, because what Oscar came up and says, these things don't matter. Man, you're making a conclusion. These things don't matter. Don't over here. Don't look at this. We want you to focus on Easter Park. Why? Ranger Freeman said Michelle Barrientes Vela was in her legal right to do everything that day. With all due respect to Mr. Reyes, he was wrong. Ken McGlamry said he was wrong. Everybody was wrong. Ken McGlamry, you have the email in evidence. They were wrong. Judge?
10 minutes.
Thank you, perfect. They were wrong. But the narrative, the snowball started. That's what got all of this here, while we're here today, going. Right? So it's not relevant. These things don't matter. And because Susan said so,
I've never heard that before from a lead investigator because fill in the blank said so. I've never heard that before. It's because the evidence says so. That's why, not because, and they didn't even double check her story. Nobody checked her bank accounts. They checked Michelle's bank accounts. Her bank accounts, they checked them, nothing, right? Ranger Freeman checked those bank accounts. He's right here, I'm glad he's here. He checked those bank accounts. He didn't find anything in those bank accounts, right, Ranger? He didn't find anything in those bank accounts. They didn't check Susan's bank accounts. Right? That's why we get so passionate about this, because it matters to not just Michelle, but to them. How do you hold the government? How do you anchor them to the Constitution? You. By your verdict, you do that. Now, I probably have 8 minutes and 15 seconds left. This is the hardest part of my job, because I have to sit down and I can't talk anymore. You guys know I want to talk, okay? But I can't talk anymore. Because they have such a high burden, because they started first in jury selection, because they opened first, because they present evidence, and they close first, and they sandwich us in. The reason why is because they have this high burden. So I can't talk, and Jason can't talk. And this is hard for me. So if you see me over there looking down, I assure you, I'm just giving you a heads up, my leg's going to be shaking, because that's just the way I work, okay? I'm going to be writing stuff down. I'm going to be responding to everything. There's not anything, I promise, there's nothing Don's going to say right now that I don't have a response for. There's nothing Don's, with all due respect, Don, there's nothing that Don's going to say right now that Jason doesn't have a response for. There's nothing Don's going to say that if you not listen to, let's take Oscar's advice for a second. Let's not listen to the distractions and the sound bites when you look at the evidence, or just think about what we just went through and what you guys have been through for 2 weeks, and thank you for that. The system doesn't work without the balance, the scales. You're the scales. You're going to know what the truth is. The truth that Michelle Vela is not guilty of tampering with evidence. The burden of proof, because is so high for the government, for good reason. The government we talked about in jury selection has the burden of proof, as the charge says, beyond a reasonable doubt. They have to remove every reasonable doubt. If you have a doubt and it's reasonable, that's not guilty. Remember we said in jury selection, people that sat all around you guys, I'm not going to mention names because of the cameras, but everybody that sat around everybody here, right? We all agreed, not sure is not guilty. If you're confused, it's not guilty. They have the burden of clarity. They have, where are my glasses? Okay, there you go, forget it. They have the burden of putting on some evidence glasses for you and making sure things are clear for you. That's their burden, not Michelle's burden, okay? The burden of proof includes the burden of clarity. The government must clearly, not suggest, clearly show that a law was violated, that they asked for cash logs, that she and her lawyer knew that there was cash logs that they were looking for, even though they knew what they wanted. They knew what they were maneuvering, and how it was violated. That and how, they have to prove both, beyond a reasonable doubt for both counts. Both counts. And as Jason showed, and I pray that we've explained, but more importantly, that the evidence showed that that's not true. So we're going to sit down, and I want to thank you. Now this is the time to thank you, because I'm going to be sitting there. I'm going to try not to object. I promise, Dawn, I'm not going to try to object. But I'm going to pray and hope that you've listened, because I know you have been watching you, and that you consider all the evidence, that you hold them to that burden. To include Ranger Freeman, with all due respect, you got to hold this whole system. The government itself has to be held to a burden, not just for Michelle, but for the community in Bexar County, Texas. This cannot be the standard to take away someone's kid or to make them a convicted felon and take away their liberty. This cannot be it. And we pray that you find Michelle not guilty, not because I said so, because she's not guilty. Thank you very much. Thank you.
Thank you, Your Honor. Wow. Okay. I want to first say, as you can tell, I'm not quite as, I don't move around like these guys. They're all younger than me. I've been doing this 32 years. I don't get all wired up, just all excited and passionate. But don't mistake that for me not absolutely being passionate and caring and outraged about their disparaging my reputation and the reputation of Ranger Freeman. Just because I'm not up here shouting about it doesn't mean that I don't think it's absolutely outrageous. Sounds like they would have me indicted, but you know why they do that sort of thing? You know why they talk about Ranger Freeman and they talk about Susan and they talk about me? Is because they don't want you to look at her. They don't want you looking at their client about what she did. So let's talk about what she did. So I'm going to first go over the things that they have just talked to you about, and then I'll move into what I want you to focus on. So they talked about Susan's desk, that it was always there, that it wasn't concealed because it was always there. Well, here's the thing. We can't go into the precinct without a reason. We end up having to go in with a search and seizure warrant. You got to have probable cause to do that. You have to develop the evidence, and you have to have a reason to know that what you're looking for is going to be there. The only reason we had to know was because Susan told us. So just because it was there and not destroyed doesn't mean it wasn't concealed and hidden from us, because it was never given to us. So just because it was always there doesn't change that. Susan did say she copied everything in the purple binder, the thing that we always talked about. Her cash logs were in the purple binder. She copied everything. She was told to copy everything. She did copy everything. They want you to believe that she never copied those and placed them in the grand jury response, but she did. And concealment. They want you to believe that not turning them over doesn't mean concealment. Well, I don't know what else you would call it. The indictment says you're concealing it from the grand jury process. Well, if you don't hand it over, you're concealing it. We didn't get it. We only got it because Susie gave us some copies, and we only got all of the originals because a search and seizure warrant was entered. They also challenged Susan's idea about, she had said that it looked like it was created over time in different pens, but Susan did testify that, well, you have a difference of opinion about what a pen looks like. It's what she thought they were trying to do. It was how she perceived it at the time. She did testify to that. O'Neill said he did work as a reserve when he worked at Rodriguez Park. And Vela, in her own words, said on that video you watched that she worked the pavilion on Easter, that in the interview she said she got $150 and Castillo got $150. And that accounts for the $300 that Mr. Reyes paid. But there's no testimony from anybody that she actually worked there. We know that Officer David worked it. We know that Pena worked the other pavilion and a reserve. She didn't work it. Why would she say that to the media? They say that there was never any mention of cash logs. Well, some of those documents don't actually have the word cash log on it. So are you saying that the subpoena has to call a document exactly by what we think it's called, or by what the person who's in possession? How do we know what they think it's called? Ranger Freeman was very specific about what kind of information he was looking for. All the information he listed was contained in the cash logs. Now I want to talk about how they're trying to move the focus off of their client and onto everybody else. It's Jesus Reyes' fault. It's Henry Guerrero's fault. It's Susan's fault. It's Ranger Freeman's fault. It's my fault. It's never her responsibility. It's never her fault. And disparaging Ranger Freeman and me is incredibly insulting. They've implied that just because we've worked together for years, that some reason, just by working together for years, that would make absolute sense that we would collude on a case. Well, let me just state, in a 32-year career like mine, I have worked with the same officers many, many, many times. Sometimes dozens, 20, 30 times. Just because you work with an officer or an investigator or an agency over and over again, it's gonna happen in a 32-year career. Every time that happens, do I all of a sudden have to say, I'm sorry? It's possible that somebody might consider that because I've known you for 32 years and we've worked many cases together that, I don't know, somebody might just think we're doing something wrong on the case. That is a ridiculous concept. I also, as far as investigative techniques and as far as what Mr. LaHood might think should or should not have been done in a report, he's not the investigator. Ranger Freeman's the trained investigator. He chose to proceed through his investigation through his experiencing and training. He's been doing it a very long time, and if he didn't know how to do it, he wouldn't be able to do it and wouldn't be employed doing it. Let's talk about the shredding. If the shredding was so crucial, why not on the day that she allegedly observes Susan shredding something she shouldn't? Wouldn't the better course be to sit down with your employee and say, let's go through this stack of documents you're shredding and let me explain why it is you shouldn't be doing this and what you should be doing right? That didn't happen. It was just, don't do that. How come you're doing that? And then finally, 16 days later, a counseling form appears and says, you shredded on the 3rd. Well, I think that timing's a little suspect. That's after a grand jury subpoena. I bet that counseling form would never have come into existence if not for a June 11th grand jury subpoena. Because now she knows there's not a whole lot of documents documenting everything, and that for two and a half years, documents are being shredded and destroyed. All of a sudden, it's important. All this time later, she's only now realizing that these documents aren't being kept around. So those counseling forms were very suspect. And how do you counsel somebody for shredding when they don't even know the policy about shredding until that day? It doesn't make any sense. So they talked about Susan's system. Messy, jacked up, I believe is what Mr. LaHood said. That it's Susan's system. Well, actually it's not. Those forms, Susan testified, were set up by Constable Vela. She's the one that came in the beginning and changed all the procedures, put all these forms into place. The very forms that Mr. Goss said were good. This did a good thing. This was a better system. And maybe it was a better system to have documentation. Susan was just following the forms and filling them out. So it was Constable Vela's system, and she was requiring Susan to implement it. And all those handwritten logs in the defendant's writing, they did not occur before June 11th. They occurred after. That's what Susan told you. It was in response to the grand jury subpoena. Use your memory to remember that and remember what she said. And let's ask yourself, why would she sit down and create those forms if not for the grand jury subpoena? There's no reason to have done it. She was doing it in response because guess what? She's the one that said stop doing documentation of the names of officers who worked. Let's talk about the wires. It's just a small recording device, and I know wire can be used as a term of art. So, you know, that's a difference of opinion. The whole reason for just wearing one is because Susan had already related that initially after the subpoenas were issued, she was told by Constable Vela to get an attorney, get a lawyer. They're after us. So she might just say something more. What that might be, who knows? But isn't it better to have it recorded than to have Susan say word for word what she remembers what was said? It's not a bad thing to record it. And Mr. LaHood said the recording exonerated their client. That's not what exoneration is. Exoneration is that whatever is contained on there would mean that she did not commit this crime. That is not what was contained on there. What was contained on there was go tell the truth. You know, just cooperate. Just tell them what you know. Well, of course they're going to say that because Susan didn't know anything. Her whole part in the process stopped as soon as an officer was supposed to work security. She didn't even know who was going to work security. It stopped. She handed the money over, and that was that. And then Mr. LaHood tried to show you about the security agreements had some of the officers' name. He showed you 2 of them. Well, if you look through the evidence that you've gotten, those 211 pages, there's not a lot of officers' assignments on there. There's some written in the margin, but that was not at all a good way to record them. And they want to say that's what they turned over. Well, officers' names are actually on the cash logs. That was the whole point, that the cash logs were in place in the first place. If somebody was going to come and accept their money for having worked security, they would sign. That is what was necessary in the investigation. Now, as far as Les Akanowitz being hired and confusing, well, I'm going to have to agree with that. I've known Les a long time. He's come and gone from the office when I was here. But he failed to follow the simplest of instructions in the grand jury subpoena. He is the one who made it confusing. He brought them to me. It clearly says in there to take them to Ranger Freeman. There was even a filled out custodian of records affidavit in there. You can see it. He didn't even do that. He didn't follow the basics. And then we subsequently had to have another meeting for me to teach him how to do it right. So he's the one that actually messed up the process. It was very frustrating for all of us. And they want to call it confusing. Well, it is confusing, but it's confusing because of her attorney. They want to make a big deal about why didn't we ask for cash logs? Well, again, those documents don't all say cash logs on the top. What if the subpoena were given to her and we said cash logs? Well, then she would not have included the ones that didn't say cash logs. It could go on and on and on for interpretation. You have to read the face of it and know what kind of content and information, and why not just give them all? Eddie Flores testified that he has never had a tampering in this context before. Well, Mr. Flores hasn't always been in this. He spent very little years in the division that I'm in. I have spent the majority of my career in this division, and I've seen it. Just because he hasn't doesn't mean it doesn't happen. Public servants.
Evidence as far as like what she's seen, she had testified to that.
So as far as public servants and investigations, he has done very few compared to me. It happens all the time.
That was never in evidence that he has done a few.
And again, Mr. Goss had said a really great question. Where's the money? And that's why we're here. So, on January 1st of 2017, Constable Vela comes into office. She takes control over Precinct 2. She changes everything about Rodriguez Park and how it's operated, everything. She totally takes control. She sets the hourly rate. She decides who's going to work it. She also decides how to process all of the documentation, and she designs the forms. We come to April 21st of 2019. It was a very unfortunate turn of events for Constable Vela. It got the attention of the media, which got the attention of law enforcement. They're not going to turn a blind eye when they hear something like that on the news. And now we fast forward to June 11th of 2019, and the first grand jury subpoena is served. Ranger Freeman serves it on the elected constable at Precinct 2, the ranking person in charge and in control of Precinct 2. She is the top custodian of records. Now, that doesn't mean she can't assign duties to other people, but she's always the custodian of records. Constable Vela hired an attorney to assist her in the process of responding to those grand jury subpoenas. She directed Susan to gather all the records, all the records. Constable Vela never provided that grand jury subpoena to Susan, who they want you to believe Susan's a custodian of records. She didn't have possession of them. She never gave it to Susan. She never directed her to read it. She never said, here, you read the grand jury subpoena, you're the custodian of records, you respond to it. She didn't do that. She hired her own lawyer to respond to it. She never told Ranger Freeman, I'm not the custodian of records, let me take her to you. Susan never saw the grand jury subpoena. She never even knew what it said or what it was asking for. She was told by Constable Vela, gather all the records and make copies, and that's what she did. She didn't distinguish one page from another. Constable Vela gave them to her attorney. You know that from the email. It's over here. Just read this. This is very telling about her knowledge on receipt of the grand jury subpoena and what her understanding is. Ranger Freeman's actually asking her for specific information. When her attorney gave those records to me, as I told you, directions very clear, what he should be giving me, the format, and that it shouldn't be me, it should be going to Ranger Freeman, fill out a business records affidavit, and it makes me wonder, why did he do what he did? I know he said it was just convenient for him, but he didn't even comply with the business records affidavit. Why would somebody not just fill that out? Maybe it's because they're a little worried about authenticating those records, or maybe saying they're complete. So by the time Ranger Freeman is contacting Constable Vela in this email, he is aware that we are missing some records. He's not missing records, but he's aware that we know there are things called receipts. We know there are things called cash logs. Susan gave him a big old stack. She gave him receipts. She gave him some security agreements. She gave him some cash logs. She didn't differentiate. She didn't just say, oh, these cash logs that maybe I didn't copy, I better show you now. That's not what happened. She copied a whole lot of things and gave them to him. So Ranger Freeman receives the records from me that Les got. He reviews the records. And this happens in a very short period of time, just a matter of days. He compares them to what Susan has already provided, and he sees that there are items missing. The cash logs are missing, and we only have a few. We don't know how many totally exist at this point in time. So now he's deciding, well, we know that some exist, so let me ask again. They want to make a big deal that it was a trap to set her up, that we were trying to somehow catch her at something because we couldn't get her at anything. Well, why would he do this? Why would he say, hey, I was expecting this kind of information? Well, that should have clued her in. You know, you forget, she's a law enforcement officer too. She has training and experience. Wouldn't that clue you in like, maybe I better look at what we gave them? Because clearly he's asking for a reason. It's not out of the blue. Mr. Salinas just reminded me that Les told you he didn't remove any documents. So who's the last person in possession of those documents when Susan gives them to Constable Vela? She is in possession of them. She tells you that in this email, that she gave them to her lawyer. Why didn't she go through them? Why didn't she look at them? Why didn't she compare them? She's actually the one representing the whole entire agency. She is the ultimate custodian of records. Why doesn't she? It's a serious thing. You have a grand jury subpoena investigating your agency. Very serious. She's a law enforcement officer. She knows it's serious. Take it seriously, look at it, find out for sure everything's there. Double check. So now we know we don't have all the records. There's potentially other records out there. The potential information that's out there is actually information that she's the one that has the knowledge of. Susan doesn't have the knowledge of the officer assignments. Remember, Susan talked about what she kept a record of. She told you where her duties end. This is the record she has. It stops at how many officers are needed for a particular event. It stops at the money, the receipt, and the date. She doesn't have anything more because that isn't her job. She doesn't know who's assigned. The only person who knows who worked, the only person who knows who was paid, the only person who knows if it was a full-time deputy or a part-time reserve is Constable Vela. She's the one with that knowledge. Susan doesn't know any of that. I'm not sure she even understands the difference between a reserve and a full-time. I'm not sure she knows which officers within the precinct are reserve versus full-time. It's not her job. She just had no knowledge of it. I think Constable Vela's reaction to the grand jury subpoena is very telling. She instructs Susan and somebody else, because we know that some of these documents, it's not just the handwriting of the defendant that was recreated. This document here, Susan testified to you that it was recreated. She didn't know whose writing this is, except for the very bottom line, which is hers. There's even officer signatures on it. You know this was recreated after June 11th of 2019, after the subpoena. That's when Susan and other people, and maybe another clerk, who knows, she doesn't recognize the writing, were told, you know what, get on it. You need to make these logs. And so they even got some of these deputies to come in and sign, but you know that they weren't signing at the time it happened. Not like these documents before, when they were actually signing as they were paid. They're not like those documents. This one was after the subpoena. This was created. So they're working on these logs. Susan's telling you it's too much. It's too hard to go back. And you saw me go through one that you have to go through several different things to just get one line entry to create a log. You have to match it up to a receipt number, which isn't always on it's not on the security agreement. And you have to match the two up. I can tell you I did it. I did a whole spreadsheet worth, and it took me a long time to do. And what I find ironic is the very thing that she's having them recreate is the very thing that she told Susan, don't do this anymore. I think that's very telling. She stopped having Susan use the forms where the deputies who were getting paid came in as they were paid and signing. That actually is a really good thing. That tracks a money trail, right? It's a good form to have. It actually protects everybody. It protects the officer who's receiving the money, and it protects Constable Vela, but she didn't want that. She changed that procedure that was put into place. She changed it. Well, why did she change it? Well, here's the problem. It would say who worked. And what if it said a reserve? Reserves don't get paid. But the person paying for security at the pavilion was paying, let's say, $300. What if a reserved work? Who's going to come in and sign that log? Nobody. Where'd that money go? Mr. Goss is right. Where's the money? Is that not an excellent reason to discontinue the use of forms where officers sign? And then now, when Ranger Freeman comes along and he's looking into the policies and procedures of the park, he's trying to figure out how it works, now she's panicking. Oh my gosh, I have to have something because otherwise he's going to dig deeper. So what does she do? She starts to sit down and she makes these. And she sits with Susan, and Susan provides information, and then she goes in, she starts filling in names of deputies, but she's not relying on anything because guess what? There isn't anything to rely on. You would have to dig up the few security agreements that actually have assignments on them. There's not a lot that have the deputy assignments because she didn't always write it on there. And the documents that Susan had, remember, Susan had documents that were copies. They were not her copies. When her copies went to her and she filled in the assignment, she didn't always give them back to Susan. They didn't have a filing system, and he's right. They didn't have a filing system. If she thought those security agreements were so important, they would have had a system. And you did see, I gave you one example where the security agreement notation did not match the handwritten logs. So that information isn't even correct. And we talk a lot about when you create a document, why is it important to do it at the time? Well, there you go. It's accuracy. That's why you do it at the time. Constable Vela is the only person who knew who actually worked, who actually got paid. Susan didn't know that at all. She didn't know who Constable Vela would pay. She didn't know if she was paying a full-time or reserve, or not paying a reserve. So now we have her creating these logs. So why did she go to the trouble of this and then not give them to us? You know, I asked that myself. I was thinking about it. I was like, well, I already know they're not accurate. So I'm thinking maybe she was like, well, I got to fill in this gap because I don't have all of this and I didn't keep track. And I don't want Ranger Freeman to think that, you know, the money didn't go anywhere. So let me create this. And then it is rather messy. I agree with Mr. LaHood, it is messy. But I think what happened is just like Susan, it's too much. It was too much. She could not remember all of this stuff, even if and I already know she didn't remember this stuff correctly. You can match it up. And these do look like an afterthought. And so she's like, you know what? I'm just not going to give him any of these. I'm just going to, you know what? I know they exist, and I know I created them, but you know what? He can't have these. He can't see this stuff. Because then he's going to figure it out. He's going to figure out what was going on. Maybe he won't figure it out because we gave him this. Maybe he won't ask the next question. Maybe he'll stop. But what she didn't know, and she didn't account for, is that Susan came to us and she told us, hey, here's some documents, look at these. And some of them happen to be the documents that she didn't give us. So when it comes to documentation, documentation is important, always important. As a public servant myself and a government employee, when I create a document, it's a government record right when I create it. I don't get to decide, you know what, from 8 a.m. to noon today, I'm going to do some writings and it's not a government record. I don't have to worry about it. That's not true. Now, that's not to say I can't toss it in the trash. It's not to say that I can't shred it. We have retention policies. When I have a criminal case, I don't shred anything. I have to keep everything. There are laws in place that require me to keep everything. So at the time she created those were government records. She was obligated to turn those over. So she didn't want to have any records of who had worked. She had that policy in place, that procedure in place. She stopped it. She didn't want any records to reflect what reserves worked, a reserve who doesn't get paid. And so why? Well, then the question becomes, who received the money that was collected from the pavilion security? It's not the reserve deputy who did the work. You already know that they're not allowed to be paid. Well, who was the last person in possession of the money? Constable Vela, for her procedures. Now, that money trail will show that for 2.5 years of weekend security, and you can do the math, cash was accepted. Susan told you that most weekends have security. And we're not talking about a small amount of money. It's in the thousands. And I did the calculation, maybe you can. We will never know how much money was collected, and we will never know how much money was not paid to the person who worked security. Why? Because she is not letting us know, because she didn't keep any records. And the records that she had, she kept from us. Why didn't she want to keep accurate records? Well, guess what? We would find out that there's money that's unexplained where it went. Yeah, we couldn't file any charges on that because guess what? We couldn't get the evidence. So no charges were filed. So let's get to motive. Who has the motive to alter, conceal, make, or use those cash logs? There's only one person, not Susan. It's Constable Michelle Vela. And what is the motive for doing that? Find out what the reserves worked and the reserves didn't get paid. And so that money, she didn't throw it away. She's the one in possession of it. If not for Susan fearing losing her job and going to Ranger Freeman to say, I am very concerned that there's something going on. I don't know what it is, but I'm concerned. I'm told I look like I'm going to be blamed for something. She told me, my boss, the elected constable, told me to get a lawyer. I am afraid. I can't afford a lawyer, but I know who I can go talk to, and that's Ranger Freeman. Look what I have, Ranger Freeman. I haven't done anything wrong. Just look at this. I'm really worried. If she hadn't done that, we would never have known about the existence of these logs. Ranger Freeman never would have been able to uncover the public corruption that was going on in Precinct 2. When we began in opening statements, I told you this is a case about public corruption, and it is. And this is a case about a cover-up of an official criminal investigation. It really does just come down to that. So by your verdict of guilty on both counts, tell her and tell every elected official out there, you can't do this.
Ladies and gentlemen of the jury, you have the evidence, you have the court's charge, and you have heard the closing arguments in this case. I have given the bailiff the court's charge of the verdict form, and he will provide you with the exhibits that have been admitted in this case. The jury charge and the exhibits will remain with you in your deliberation room. Once you have assembled, as I explained earlier, once you have assembled in the back, select your presiding juror, and you may begin the deliberation. So what that means is that I am releasing you now from the prohibition from talking about this case. Now this is the time that you talk about the case and you consider the evidence. At this time, follow the bailiff to the jury room. My two alternates, you're going to follow him to a different room, okay? We stand in recess.
All right, for the jury. Your books.
no, this is all there. He added to the box because of the disc. This is the only thing that was, I figured out. Is it, all right, yeah, I'll still put that disc in there and give you the other one.
Yeah.